Good morning, everyone. Welcome once again to the second session of today during the proportionality test session. During this morning and part of the afternoon, we'll have a great panel. We have two professors that have a lot of experience, have discussed a lot this topic, and that have a very close approach as well as original approach with the proportionality test, as well as its stages. As always, you are all invited to raise your questions via the chat box. So please write them in the chat or in the social networks where we are broadcasting this. First of all, we'll listen to Professor David Bilchitz and then Professor David Martínez Zorrilla. David Bilchitz is Professor of Fundamental and Constitutional Rights in the University of Johannesburg, South Africa. And today he will be talking to us about proportionality and exploration of the multiple dimensions of the necessity test. Professor Bilchitz, thank you so much for agreeing to participate today. It's a pleasure to have you here as always.
Gracias por la invitación de presentarles y lo siento que no puede presentar en español. Now I'm going to just share my screen. There we go. Okay. Can you all see? Yes, brilliant.
Sí, sí.
Hey, great. So I'm going to talk to you today about the necessity test, but I'm first going to introduce it a little bit and talk about the fact that fundamental rights have a high level of normative importance. They are enshrined in bills of rights and international covenants, but rights are not absolute, as we know. They can be limited by important social objectives of sufficient importance or by other fundamental rights. And so whether a limitation is justifiable is an important legal question, a limitation on a right, okay, whether it can be justified. And it is critical that that not be left simply to discretion. Now, interestingly enough, there's a remarkable convergence across countries in their general approach to limiting rights. And the common focus across the world, this global idea that has been developed, has been the notion of proportionality, okay? And the proportionality test. And in terms of that test, ultimately, courts weigh up the importance of the objective of the infringing measure, the measure that infringes a right, and they weigh that up against the harm that is caused to the right. And the key benefit of proportionality is that it gives us a structured reasoning process to make sure that there is an objective and that the measure is related in some senses to achieving that objective. And the proportionality test has various stages. Okay, the first pre-stage, we can say, of proportionality is one has to decide whether a right has been infringed in the first place. Okay, and there's a presumption in favor of a right, usually, that it should not be infringed. And that requires interpretation of the content of the right, understanding what the right protects, and whether what the right protects covers the particular case before the court. If it covers that, there is an infringement. But that doesn't end the story at the constitutional level. We need to consider whether that infringement of a right can be justified. And that's where proportionality comes in. And in doing so, and I'm sure many of you are familiar with this, one needs to consider the purpose of the infringing measure. Why is the right being infringed? And whether that purpose is a legitimate purpose. Okay, most courts don't go into that in too much detail, but it needs to be clear that it's not being done it's being done for bona fide social purposes and not, for example, corrupt purposes. Then there's the need to consider the relationship between the objective and the means of realizing it, okay? And there are two stages to that test. The one is what we might call the suitability stage, which requires that there be a rational connection between the means and the objective, and the necessity stage, which says one must impair the right as little as possible when achieving the objective. And the last stage is balancing, which says that the benefits of the infringing measure must be proportional to the harm caused by the violation of the right. Each of these elements requires some discussion, and I'm going to engage today with you with one of the most important elements, what we might call the necessity test, okay? And that is a critical element and perhaps one of the most powerful dimensions of the proportionality inquiry. Now, in preparing for this, I was looking a bit at the Mexican Constitution to try and understand where proportionality fits, and I saw, I'm sure you are all more expert than I am in this, but it didn't seem to me there was a clear textual inclusion of proportionality. However, one needs to read in proportionality in order to address the limitation of rights by a social objective or where rights clash. And so I saw, for example, that the Supreme Court had adopted a proportionality in a case relating to the dismissal of an HIV positive soldier known as Esteban Cabrera, and that it was in a sense needed to balance the competing considerations. And the necessity test allows us to consider, right, assuming there was a legitimate objective, which is a question in this case, right, but let's say there was a health concern relating to the army, was dismissal the only alternative to be able to achieve the army's purpose, okay? And clearly it wasn't, right? If someone is not well, it's not generally necessary to dismiss them. You may be able to move them to another position or something like that, okay? And so the necessity test is generally useful in relation to most rights where negative obligations are at stake. So it's useful generally when there's an infringement on a right, where there's a duty not to harm the right, and you have to decide whether the right has been harmed permissibly or not, okay? It is generally not that useful in the realm of positive obligations. And I have a new book coming out on the fundamental rights and the legal obligations of business in the next month, where I look at proportionality and its usefulness both in negative and positive obligations, and I try and provide reasons why it is not that useful in relation to positive obligations, which deal with evaluating an omission by the government or other actor. Now, I also saw when I was looking at the Mexican Constitution that Article 6 on the limitation on expression of ideas is also potentially an area where proportionality comes in. But ultimately, it is actually relevant where negative obligations are at stake, potentially to all the rights that are recognized, okay? So we've talked a little bit about why is necessity important. I'm going to suggest to you that courts around the world have adopted what I call a strict interpretation of necessity. And that has led to a number of undesirable consequences whereby courts adopt strategies to avoid engaging with the test and to address the serious consequences that would arise if it did apply the test in the way they formulate it, okay? And so I argue for a moderate interpretation of necessity, which includes, perhaps controversially, a limited component of balancing. I break down the necessity test. Now, you might think proportionality already has stages. I break down necessity into 4 stages, okay, or 4 elements: possibility, instrumentality, impact and comparativity. I'll talk to these things so you don't have to worry about the fancy words at the moment, okay? And I will argue that necessity is a critical component of proportionality, but must be conceived of in a way that is useful and protective of rights, okay? So I hope this will be helpful to you. I have written an academic piece, which I think many of you have also looked at, and this talk is based on that piece. I'll hopefully try and illustrate some of the ideas as well, and we can also have a debate about these issues. Okay, and I'm going to, as I go through, I'm going to keep an example in mind. This comes from my context. The South African Constitutional Court in this year released a fantastically interesting judgment dealing with a very topical issue of government surveillance, right? The surveillance the government has over our social media and our mobile phones. And it looked at some of the permissions that were granted in law, and it struck down most of the surveillance elements as unconstitutional. And it also prohibited bulk surveillance. Well, at least it sent it back to Parliament to provide some guidance in that area. Now, this is a very interesting area. You might have similar cases in Mexico, so you might want to look at the case. But I'm going to focus on a particular issue which dealt with how long is the state entitled to keep the data that it intersects in private communications, right? We have here an infringement of a right. And then the question is that justifiable? Now, there's clearly justification and there can be legitimate purposes, for instance, for combating terrorism or crime. But we're now concerned with that question of how long can it keep the data? And I'm going to, throughout, use this example, considering two alternatives. It can keep the data for 3 years, or it can keep the data for 6 years, okay? We'll come and think about how do we think about this case in relation to these two options. So let's go into the strict interpretation of necessity. This is the formulation of necessity by many courts around the world. For example, the German Constitutional Court said a statute that violates rights is necessary if the legislature could not have chosen a different means which would have been equally effective, but which would have infringed on fundamental rights to a lesser extent or not at all. Okay, and the Canadian Supreme Court has also said the means should impair as little as possible the right in question. So what is the point of necessity test? It forces a consideration by courts when dealing with infringements of rights of alternatives, alternative means. And it ensures that even if there is a worthy objective, rights are not impacted upon more than is necessary, okay? To make it meaningful, however, we need to ensure that we have a proper understanding of the test. And there are two questions that are raised by the strict interpretation. When is a means equally effective? And when is a right impaired as little as possible? The strict formulation of the necessity test can be, I argue, both too difficult and too easy to meet. Why? Well, it can be too difficult because one can always come up with an alternative, so measures will not pass it, right? So if you say, for example, well, the state can keep information for 6 years, well, why not 3 years? And then why not 2 years? And why not 1 year, right? You can always kind of reduce it in some ways, right? And Judge Blackmun from the United States said the following: a judge would be unimaginative indeed if he could not come up with something a little less drastic or a little less restrictive in almost any situation, and therefore enable himself to vote to strike the legislation down, okay? So if the test is too difficult to meet, then we will continually have legislation being struck down because there are alternative means that infringe the right less. On the other hand, it could be too easy to meet, okay? And that is, why is that? Because it's about the equally effective element. So we could say that measures, alternatives are never equally effective to the legislation and the exact way in which the legislation is designed, okay? And for instance, there you could say, well, the state's objectives relating to fighting terrorism or crime can never be equally met by a 3-year restriction. It can be better met by a 6-year restriction. So 3 years is not equally effective to 6 years. Okay, so therefore the legislation will always pass the test, and therefore the test will have little effect, right, in testing legislation. Okay, so in order to address this, there have been a number of issues, right? The first problem is a separation of powers issue. Requiring the least restrictive means invites courts to substitute their own judgment of what is best for the legislature's judgment. And that raises the traditional concerns about the competence of the court and their legitimacy, okay? And so in order to address this, courts often avoid the issue and defer to the other branches of government. So the German Constitutional Court adopts a very strict test, but it says courts have limited power to review the legislature's judgment that a measure is indeed necessary, right? So that shifts the focus from what must be determined, what the test is, to who should decide whether a standard is met or not. And the result of this is it reduces the power of the necessity test and it widens the discretion of the legislature. So the German court adopts a strict test, but basically refuses to engage a lot with the test. It says, well, it's in the legislative discretion. So what's the point of such a strict test? Okay. And so here are some of the objections to such deference, right? It abdicates proper responsibility to determine whether a right is justifiably limited, right? Either a limitation is necessary or it is not necessary. It makes no sense to state necessity as a requirement, but then to defer judgment to the very body whose measures are to be tested, where the standard is impugned, okay? So you're essentially deferring to the body which you're supposed to test, right? Proportionality is a reasoning process designed to ensure the important normative considerations are given the weight they deserve. Refusing to engage means that the very point of the test is lost. And that in turn reduces, the second objection, reduces protection for fundamental rights. When should courts look deeply into the question of necessity? And when should they defer to the legislature? That's not entirely clear. And Sujit Chowdhury has said that the Canadian courts have struggled to articulate, for instance, an adequate basis for according deference in some cases, but not in other cases. Without clear criteria for when to defer, necessity loses much of its force, okay? And so, ironically, a high standard of necessity, a strict standard applied with a high level of deference, grants little protection to rights. A second problem, which applies actually more generally in proportionality, but arises here, is the lack of evidence. The strict interpretation suggests that strong evidence is required to show that a measure is necessary. And Chowdhury also raises the problem that public policy is often based on approximations, extrapolations from available evidence, inferences and comparative data, and even educated guesses, okay? The government may not be able to justify necessity to a high degree of certainty, okay? So in order to address this problem, courts have often tried to presume necessity. Some judges say the burden of proof is on the applicant whose rights are violated, and the statute must be presumed to be constitutional. And the presumption attempts to lessen the impact of the strict standard and address separation of powers concerns. Okay? However, a presumption in favor of constitutionality is really a problem. It's an abdication of responsibility to reason through the elements of necessity, and one only does so if the presumption is discharged. Rights should enjoy a presumption against limitation rather than one in favor of limitation. It goes against the very nature of rights, because rights have a strong importance. So the presumption of constitutionality weakens rights too significantly. Okay, so there are various problems that I've gone through with adopting a strict interpretation. Okay, and all the strategies of avoidance I've talked about tend to reduce the role of necessity in a way that runs the risk of weakening protection for rights. So the question then becomes, how should necessity be approached? Okay, and we need to address some of these challenges. We can't set the standard too high, and we also know there's a degree of vagueness. And so that's where I came to try and outline a moderate interpretation of necessity. And I did that by looking at, starting off from the justification for the strict interpretation given by Robert Alexi, who I'm sure is very well known, I know, in Mexico and Latin America more generally. Okay. So the principle of necessity, Alexi argues, flows logically from the nature of fundamental rights. Rights are principles rather than rules, he says, and principles are what he calls optimization requirements, norms that must be realized to the greatest extent possible. And so the outcome of that conception means that we need to realize to the greatest extent each principle in a way that is compatible with realizing other principles. But the problem is that optimization works for economic goods like profit, but it is vague in legal and moral matters. Okay? And so I argue, in a way, principles should be rethought in some ways to be considered weighty reasons which have a strong weight, but not necessarily optimization requirements. Now, from this view, that's quite theoretical. I want to break down the test into 4 components and suggest to you why the strict interpretation is mistaken and how we need to modify it. Okay, so a measure, the first element is what we might call possibility. A measure is only necessary if there is no possible alternative that will equally realize the objective, but have a lesser impact on the right. Right? That's the formulation of strict necessity. But there's a question mark. What is included in all possible alternatives? Does this mean logical possibility? Surely not. Physical possibility. These are ideas you can read in my piece, but they're too wide and they leave too little room for limiting rights. They're too extensive, right? It might be physically possible to build cable cars everywhere, but it's too expensive, impractical, environmentally harmful, etc. What about practical feasibility? Well, that itself has an uncertain scope. What role do we have there for economic scarcity, and when is economic scarcity real and not constructed? What about political sensitivities? Is something not possible because the population will rebel if it is imposed? Okay, and that runs the risk of being too weak. It allows majoritarian rule, for example, if you take political sensitivity into account. So the notion of possibility has significant variability, and it entails normative and substantive reasoning. Courts cannot simply defer if the test is to have bite. The idea, in my view, is that the parties should place the leading alternatives it wishes to be considered before a court. Practically, that's how they should do it. If you wish to assert a possibility, you need to put it before the court, and the court can then interrogate whether it is itself feasible and various other aspects relating to the alternative. So once we've identified an alternative, we need to consider the stage of instrumentality. This really involves looking at the relationship between different means and the ends to be achieved. You've got the legislation, for example, and the alternative, and you need to weigh them up and whether they are effective, whether the means has an effect, does achieve the end. Now, we know that the test has been formulated as equally effective, okay? But equally effective is a very high standard, as I said, which weakens the testing significantly, okay? The German Constitutional Court characterizes the purpose so that no alternative means will ever really be equally effective. The Canadian Supreme Court reformulates the test, and I would suggest to you this is sensible to say whether an alternative means will achieve the objective in a real and substantial manner. The Canadian approach is more realistic and makes more sense of the test. So importantly, the court exercised discretion when considering whether feasible alternatives realize the objective in a sufficient manner, in a real and substantive manner. It must still realize the objective, otherwise you're not talking in the same ballpark, but it doesn't have to be equally effective. It must be substantially effective. The third stage is what we might call the impact stage. What is the impact of differing measures on fundamental rights? This involves a qualitative normative judgment by courts without clear precision. But it's done by courts all the time to evaluate impact. The problem is the courts often do not demonstrate a willingness to engage with the content of rights and the degrees of their impairment. To improve reasoning, it is necessary for them to do so. Okay, that's a critical issue for courts in general, to actually think carefully about the content of rights and the extent to which they are impaired. And the last stage of necessity involves a comparative judgment. Is the measure the least restrictive of the feasible alternatives? This requires the evaluation of whether an alternative measure exists that sufficiently realizes the objective while having a lesser impact on the right. Now, this becomes a bit complicated because there are two axes of this comparative exercise as to which alternative is best. The one is the manner in realizing the objective, and the other is the impact on the right. The judgment involved in necessity is whether there is an alternative that has a lesser impact on a right, but still achieves the objective in a real and substantial manner. And there is a comparative exercise here that involves some balancing, right? And I try and show, I'm not going to go through this, that there's a bit of a trade-off sometimes between the impact on the right and the extent to which the objective is realized. And I illustrate this with that case I told you about from South Africa on surveillance, okay? How long was the question, is it necessary for the state to keep intercepted data of private communications? 3 years or 6 years? Now, are the objective served by storing surveillance data is to assist with ongoing investigations into serious crime and national security threats. Now, clearly, the longer, the greater achievement of the objective. But is 3 years realizing it in a real and substantial manner? The impact on rights, of course, the longer the data is retained, the more invasive the privacy infringement and the potential for abuse of the data. So the alternative measures may both realize the objective in a substantive manner, but one does it slightly better than the other, the 6-year law. When is that offset by the lesser infringement of rights? the 3-year law. Okay, as I've said, less time for data storage, the less efficiency to achieve the objective, but the greater gain for privacy. The more time, 6 years, the greater efficiency for the objective and the harsher effect on rights. And so we need to, in this stage, essentially balance the security objective versus the privacy objective, the impact on rights. And so I try to show through that there's a limited level of balancing involved in this component of necessity. This doesn't mean that the necessity stage collapses into the last stage. No, I argue that isn't the case. Necessity does not answer the normative question, which is in the last stage, of whether the benefits of the measure outweigh the cost to the rights. So even if we decide that 3 years is a decent alternative, okay, and that would pass the necessity test, one must still evaluate whether the benefits of security in relation to surveillance outweigh the harms to privacy in that case. And that is a normative judgment at the 3rd stage, a difficult one, which is why the 3rd stage is quite controversial. And we have to consider that wider inquiry at the 3rd stage. So the moderate interpretation of necessity says all feasible alternatives must be considered before the court, with the court being explicit about its criteria of feasibility. Secondly, the relationship between the measure under consideration, the alternatives identified, and the objective sought to be achieved must be one that involves sufficient realization of the objective. We need to evaluate the differing impact of measures on fundamental rights assessed, and there's an overall comparison between the measure and alternatives and whether the government measure is best in relation to the 2 axes I outlined, objective and right. Now, this approach that I've adopted, in fact, is not only my own views now, it has become law in India. So the Supreme Court of India thought that what I said about the necessity test made sense. And in relation to a case, I put it over here, that dealt with a privacy challenge to the National Biometric Identification Scheme called the Aadhaar program, the court has to consider the necessity requirement. Okay, it also, again, was dealing with data collection or processing. And the Supreme Court thought that it's important to think carefully about the necessity test, adopted my moderate interpretation of necessity, and then sought to apply it to the facts, and it upheld some aspects of the scheme and not others. Now, I'm not saying necessarily that the court got it exactly right in the way it applied it, but it nevertheless recognize that we can't just apply necessity in a way that is too strict and therefore deprives it of meaning. Okay, so if you want to have a look at the other judgment, there was one other judgment that has also applied this in India. So in conclusion, fundamental rights are not absolute, but they deserve strong protection, and proportionality is a way of requiring a strong justification for any limitation of rights. The necessity test is a vital part of proportionality. It requires an evaluation of alternatives and whether an objective can be achieved by less restrictive means. The way in which the necessity inquiry is conducted can tend towards either rendering rights absolute or offering them little protection. A more moderate interpretation is possible, which I argue affords significant protection for rights, but allows for their limitation in suitable circumstances. And that's what I've sought to outline today. Ultimately, qualitative judgments cannot be eliminated from a determination of necessity, but a clear reasoning process can help guide the judgments to be made by courts. And I hope that this is perhaps helpful in guiding the development and approach to proportionality and the necessity test in Mexico and by your Supreme Court. So thank you for listening to me, and I look forward to discussing these ideas in question time.
Muchísimas gracias por su presentación, Profesor Bilchitz.
Thank you so much, Professor Bilchitz, for your presentation. I'd like to remind all of the participants that logged on from our platform that Professor Bilchitz's article on necessity is available in Spanish in that platform, so that you can consult it, read it, it's available. And now we will hear from Professor David Martínez Zorrilla, philosophy professor in the Open University of Catalonia and Pompeu Fabra University. His presentation is on, is it possible to underline the distinctions between principles and rules? Thank you so much, Diana. Good morning in Mexico. Good afternoon in Spain. Wherever you are logged on here. First of all, I'd like to thank you for inviting me to this session. It's an honor to be part of this panel when we have expert professionals such as we have heard right now. So I'll try to keep up the pace and try to share useful things with you. From my perspective and my experience, I will try to share as much as I can. I don't know if you are seeing my presentation or if you can see me. Yes, we can see you. Okay, so I'll try to share my presentation now. Let me know when you can see it, please. We can see it now. Okay, without further ado, let me get started. So when I received the information to this session, the first question I tried to answer was to write about this topic within the framework of this session. So I started thinking that it might be interesting to share with everyone without dwelling directly in the proportionality aspect. So it's very interesting to me to do the distinction between principles and rules. This distinction has been brought up by important authors such as Dworkin, which is the highest reference to this topic. And they placed principles in a very conceptual term. Proportionality is linked to the structured norms and principles. When we talk about principles in law, we know that it has a long historical tradition, but it is specifically through Dworkin's work that it caught more relevance. One of the main arguments to criticize the positive conception of heart. So in this positivism conception, they don't identify principles as such. But what I'd like to share basically with you about rules and principles is to identify up until what point they can be maintained solidly, and also what impact does this relation have with proportionality? So the distinction between principles and rules is one of the most controversial and debated aspects in law, as you probably know, and this is because of three reasons. The first of all, there's a lot of heterogeneity and variety in the exemplification or identification of the category principles. For example, we have the in dubio pro reo principle, where there are many elements and characteristics. There's also this principle referenced to a very specific issue when it comes to the legal process. We also have the principle of the separation of powers, which we heard a little bit of, and how the institutions have to be organized. We also have the principle of the freedom of form in contractual relations of private law. So this is through concrete norms. And what is of most interest of us, we also have considered as principles the fundamental constitutional rights, such as the freedom of expression. These are seen as principles as well. So as you can see, we have a variety of elements that is quite meaningful. And moving on to the second reason is the nomenclature, the naming, how we refer ourselves to these terms, or how even the legislation uses these terms. It's very common to hear expressions such as supreme principles, fundamental principles, constitutional principles, general principles, implicit principles, and principles, period. This might be also meaningful and interesting to know. The third reason, and probably a very important reason from a theoretical point of view, is the theoretical propositions to categorize theoretically this concept. So we have several classifications and categorizations. There's a lot of creative ways to classify them. I personally really like a map created by a professor in Portugal called Moniz Lopez. I have also found out that some people deny these categories, but other people like to have these categories, although they have a gradual or weak interpretation of these. There are some tools that tend to go more towards principles and others that go more towards rules. So we have the distinction of equal or weak, where we move more towards the rules or towards the principle. We also have the strong distinction where X is either a rule or a principle. Once we have accepted this distinction, we can base our arguments on different criteria. For example, some authors use the semantic distinction, and they talk about the degree of vagueness or abstraction. Here, we refer to some norms that are more abstract, more generic, and that reach an important level of moral nature. There are other authors that base their criteria in the syntax, so the structure of the norm, the logic structure of the norm and its relations. So all the connections we see between the elements. So rules and principles are public norms that have a different structure and that make this quantifiable or not. We also have authors that use a criteria in a more pragmatic way. And here it's basically how they operate in the legal argumentation and the justification of decisions. So what are the reasons used in order to make a decision whenever there's a controversy? So we're talking about reasons that are prima facie, so that they can be dismissed or defeated by others, by other reasons, or rather if these are definitive reasons that determine the others. So all of this variety at different levels is not really useful to get to a clear conclusion or definitive conclusion. However, it does allow reflection and ask ourselves if the distinction, or rather the category of principle, can be seen as a homogenic category. We know that when we talk about principle now, we talk about different categories, different concepts, and there's a lot of variety. We have authors such as Garcia, Martínez, and Bravelsky who argue this point. But by having so much variety and categories, we might get the impression that no matter what principle we're taking as a foundation or as reference, in some way or another, we'll always get to the outcome that according to there are elements, according to the secretary, there are elements that jurists might include as principles, elements that usually should not be included as principles. So Guestini states this in a very clear and illustrative way. All distinctive proposals assume that there's only one type of principle, or in all cases, the principles that have one or more common properties can be reduced to a unitary concept, so one concept. If we start from this point, if we consider that that the principles are no homogeneous category, then more questions come up, such as establishing a conceptual relation between principles and distinction. If we know that principles are variable and have different categories, how can they create this conceptual relation with the consideration? So it's important to take all of these criteria and propositions of distinction into account. Especially those that are brought up by Dworkin. From Dworkin's point of view, and one of the main arguments to protect the law, Dworkin makes a strong distinction between an X principle and a rule. However, it's not very clear if he uses a syntax or pragmatic criteria. So he seems to be mixing both of these criteria. And it appears as if he's stretching the concept, because on one hand, when he talks about rules, he refers them as closed norms, a all or nothing approach if the conditions are good to solve the case, and he considers principles as open norms with a weight dimension, and this means that principles give prima facie reasons that tilt the scale towards them, but there's still no definitive definition or solution for them, because they can coexist and they can interact with other principles and other elements that might clash with them. And so in the end, that other principle will have to battle it out. So we have these two dimensions. On one hand, we have the syntax structure, where some rules have closed applications. And this can be interpreted from the most analytical legal theory. And we can see that rules establish unbeatable conditions. And this is what is called the precedent rule. So for example, if we are driving in a street and there's a red light and we stop, we all know that we need to stop. But for example, even if it's raining or if there's traffic or if it's Friday afternoon, you still need to comply with that red light. You need to stop at the red light. So that is a rule, otherwise you will have to pay for the consequences. For some jurists, it's also quite obvious to see that norms that are seen as rules that are also subject to inspections. There are some circumstances that are foreseen here that make us pay attention to the consequences of those rules. For example, there's a norm in a legal code of having 20 years of prison, but it can be beat if the subject has certain conditions. For example, if they are not over age or legally of age. So there are several elements. In the case of rules, all of these inspections can be listed as exceptions. So in principle, it is possible to rebuild all the exceptions. However, this is not possible with the principles. Principles have open applications. This means that are beatable norms. And conceptually, it's not possible to list all of the exceptions with the principles. So as you can see, we have a different structure, a different syntax between rules and principles. There's also the pragmatic element. Here we have rules that can be applied through a coordinated framework where the cases of the conflict can be solved by clarifying the validity of a rule or introducing an exception. But the pragmatical element, when it comes to principles, we know that it has to apply through a process that can let us know if there's an exception to those principles. However, it does not apply with the principle that takes into account the relative importance of each case. And this is why that in a context of conflict, although we give preference to one of them, this doesn't mean that the other one is not valid or that there's an exception. So regarding on the circumstances, one principle will win over another. So this is Dworkin's position on this. And so what are some difficulties about the pragmatic element? And as Dworkin and other authors say, we could incur in an internal inconsistency when we assume a principle that can be the exception to the rule. So we have here the clear example of Riggs versus Palmer, where we were able to set a precedent. There's also the horse of Troy argument set by Bayon that states if one principle can be the exception to the rule, then by definition, principles are also close to application conditions, and therefore rules are also principles because rules are also open to conditions, and so all norms are principles and there will be no criteria for distinction. On the other hand, Dworkin shares the following with Alexei, where they do not conceive situations in which when there is no collision or clash between principles, or where there's only one principle involved. For example, poetry and freedom of expression. So where we exercise the right to freedom of expression, and this shouldn't have a clash with other principles. For example, if I write a poem there is no principle or reason to beat what I've written because of freedom of expression. So besides this, it's also important that in order to determine the action or the activity and to make sure that it's the exercise of a fundamental right and a principle, we need that distinction. So for example, if we write a poem on spring, this is an activity. a substantial activity. However, the action of writing a poem is an activity that does not exempt the other. Regarding Alexi's position on rules and principles, just as Dworkin, he assumes a strong distinction between principle and rules. And here, the distinction is a bit more clear than Dworkin, because he bases his idea on the concept of optimization or maximization. So rules for Dworkin, they are closed norms. They have an all or nothing application. And Alexi appears to share that vision with Dworkin. And when it comes to principles, Alexi took the next step in optimization principles. So we see here an evolution in Alexi's construction of principles. So we see a meaningful change here in the theory. So we have first the conception of principles as optimization mandates, and principles as the objective of the optimization mandate. And further on, in a very subtle way, he manages to define principles not as optimization mandates, but as the objective of those mandates. So the principle has to do with the duty of optimizing or maximizing a norm to reach satisfaction. So what we need to optimize and maximize is the norm rather than the principle. So this is the first vision of the principle as optimization mandates. Here we have norms that demand something to be obtained or reached in a best possible way, taking into account the legal and feasible possibilities. Compared to Dworkin, the openness or non-determination does not focus so much on the application of the conditions, but rather the legal consequences. So here the idea is that the norm can satisfy or can be fulfilled in different ways and in different levels or intensities. From this point of view, principles for authors such as Ruiz Manero, principles are adjusted to the categories of the norms. And it's up to the juror to reach that objective with all the resources available. When it comes to action norms, these are norms that regulate the behavior. For example, if it's forbidden to smoke or something else that will have an impact on the behavior. For example, we need to look for the well-being of children in development. That would be an action norm. What are some difficulties that we might face with this way of perceiving principles? If we see Alexi's model of principles seen as mandates, this model would go hand in hand with what Dworkin says regarding policies and what would in some constitutional texts appear as social rights. that are not seen legally as subjective, genuine rights or claims. So these social rights or claims, most of them are part of what the constitutional calls guiding principles of social and economic policy. This is from the Spanish Constitution, where we see how, through certain obligations and duties to the public powers, they will need to satisfy as much as they can, taking into account resources and everything else, satisfy the objectives that need, but these cannot be claimed legally because they are developed in general. So for example, protection of childhood or elderly people or promoting culture, these are seen as guiding principles of the social and economic policy. However, you cannot go to the judge to claim the satisfaction of those rights beyond the measures that legally have been established for protecting or promoting those rights. For example, in Spain, you cannot go to the court in front of a judge and ask for a household, but you need to go through the legislative measures and principles to try to promote and foster a safety household or to a better price. Or for example, fiscal benefits, etc. In this sense, these rights can be satisfied at different degrees and different intensities. However, and paradoxically, when Alexi thinks about principle, he mainly thinks about a very important category, which is the fundamental rights in the strict sense. So fundamental constitutional rights. In this context, which is all of the freedoms, freedom of expression, etc., here we don't see a partial satisfaction for both. If something can be categorized as an example of a infringement of freedom of expression, there is the legal right to protect that. And when there's a conflict between fundamental rights, we cannot have a partial satisfaction for both parties. If I have limited resources and I need to allocate them for culture, health, and education, for example, it won't be possible. But if I have a conflict with fundamental rights, the final consequence is that one of them will prevail over the other. And another example of Alexi is the conflict between freedom of expression and right of norm. And in the end, one of the rights prevails over the other. It's not there is no partial satisfaction. One right has been sacrificed over the other because it's considered more important under those circumstances. Another difficulty to conceiving these principles was a critique done by author Arnio, and he states that there is no relevant difference in the structure of both categories in the measure that one optimized mandate can be complied or not. It can either be optimized or not. So in this sense, the structure of this mandate will also be in nothing or an all or nothing optimization. And here we question once again the distinction of the terms. As a consequence of these critiques by several authors, including Arnio, they appear to change their perspective on principles, and they now perceive them as the object of a optimization mandate. They consider principles as norms that should be satisfied or complied with, taking into account legal and viable possibilities. So here we need to satisfy a mandate or apply a norm in the majority of the occasions possible in which those conditions apply. So rather than an optimizing or maximizing mandate, it would be the optimization or maximization of a mandate. For example, we will respect the freedom of expression in the largest number of circumstances regarding legal norms. There are some issues with this point of view, and here we have author from Lisbo, Ramiao, that states some challenges from the previous theory. So the qualification of something as principle or rule will depend on the existence or non-existence of a meta-norm that will ordain the maximum mandate, and not the priorities, structure, or categories. So it wouldn't depend on these elements. This means that a norm does not depend on the characteristics of a maximized norm, but on the norm that can allow us to maximize it. So norms that have the identical structure can be principles or rules in function if there is the existence of this meta-norm optimization. On the other hand, according to Alexi, the distinction of rules and principles depends on this meta-norm and not the object norm. And if we break down the classification in an exhaustive and exclusive way, the object norm will necessarily become a rule, regardless the structure or the content. So the object norm has to be a rule. If it's only a principle, but if there's a meta norm, then this norm, regardless its structure or content, should be considered as rule. The third point, Alexi does not question Arnio's affirmation regarding the all or nothing characteristic. Therefore, the meta norm also has the structure of a rule, so it becomes a meta rule. So this, in a principle, a meta rule will force to optimize a rule, which is a bit weird for the distinction criteria. And there's another interesting issue, because when we talk about meta rules or meta norms for optimization, we have two alternatives. They can either optimize by being explicit or implicit. Explicit in the law, in the Constitution, or they are implicit. We presume them. It appears to be uncommon to have explicit rules that will force to apply another one in the legal system. So this is weird, and it's probably doesn't exist. But here it's important to notice that we talk about implicit meta rules that are not expressly formulated in the Constitution. So if we talk about implicit meta norms, that help us to develop other norms, then this element seems to exist in all cases where the authority dictates a norm, including those that are seen as rules. This means that we assume that any authority that dictates a norm has the obligation to apply this rule to make sure it's complied with in all the situations where it can be applied. For example, when a legislator issues a rule, issues a norm, and is seen as a rule, then the authorities that receive that rule need to carry it out with the fair conditions. And for example, here, the meta-norm has to be complied under any circumstances, even in the most general level. When a mother tells her son, go to your room, or you cannot go play outside until you finish your homework, then that norm has to be complied and satisfied with as much as possible. This is something that comes in implicitly with issuing the norm or rule. So we issue a rule so that they can be fulfilled and complied with. If a meta norm exists in all cases and we have meeting the satisfaction element, then those norms are also principles according to that criteria. So the criteria of distinction cannot work if we consider norms as principles. Another possible interpretation that might be more flexible for Alexi is the optimization criteria he uses. And here it has to do not much with the legal aspect, but with a justice criteria. You have 3 minutes, David. Okay, thank you. I have a couple of slides left, but I will keep it short. Thank you. So as I was saying, we need to understand it as a justice criteria in the sense that the obligation directed to the public powers to develop and protect fundamental rights could be understood as an obligation that can protect these fundamental rights as much as possible, as long as they are compatible amongst themselves. This mandate can be easily understood, such as the first principle of Rawls' justice, where there has to be compatibility between the systems. So there is an obligation from the authorities to protect fundamental rights, and so that they can still be compatible amongst themselves. The optimization mandate is not so a legal thesis, but a rather philosophical thesis regarding justice. What can we say about all of this? We can say that most of the most important principles and propositions, sorry, for distinguishing rules and principles, have issues in being clear. So we question the plausibility of distinction. And now let's look at the link and relation between principles and considerations. It's important so to have a relationship, a connection between the concept of principles and assumption. Because if the structure of the principle is not clear, then it's difficult to extract a conceptual outcome. Alexi is one of the defenders of these principles, stating that the conceptual connection affirms the structure of the mandates in the implied optimization of them. And the distinction comes on how to apply the rules properly. There are some challenges regarding this connection. First of all, as Dworkin stated, let's imagine situations where there is no conflict between principles. It's not clear, so it's not clear what type of assumption can be applied to the case and what principles can be applied if they overlap. So we can think of a more restrictive but also more benevolent interpretation that can sustain the conceptual link between the situations of conflict of principles and rights and assumption. This means that assumption in proportionality is how conflicts are solved between principles. And because the classic resolutions are not applicable. The special criteria here are not applicable. So in any case, as authors such as Ferrer and Ratti have mentioned, conceptually, we cannot exclude the assumption as a method to solve conflicts between rules. So there's no reason why we can use these elements to solve conflict. This is why I think a more adequate way of applying proportionality and assumption is through a normative. We know that assumption is the best and most used method to give a justified answer to conflict situations between principles and rights. However, in the connection of this is not conceptual, but rather normative. This will be all for my part. Thank you so much, David. Could you please get closer to your microphone? We are having a very hard time hearing you. We do have a lot of questions for both Davids, and we don't have a lot of time left, unfortunately. So let me explain the following. I will share the pool of questions that are for both of you, and then more specific questions. And feel free to answer a question, even if it's not stated to you. That's even better for us. So the first question has to do with the big concern with the coincidence of both presentations regarding Lexi's theory and that we have discussed. And principles are optimization mandates, and both of you have objections regarding these different consequences. However, the question is if you can go into more detail, more positively, what are understood as principles, and if the category of principles should be something we should rethink, because there are so many different elements that instead of uniting them, they confuse us even more. So this question is for both of you. We have also, I'm mentioning this because David mentioned that principles should be better understood as reasons with larger weight instead of optimization mandates. So if you can specify the differences, this idea. The second general question is to elaborate your position regarding social rights. If you consider them as different categories to civil and political rights, or if this distinction is a distinction that is not worth keeping. Now, specific questions for David Martinez. The first question for you, David Martinez, is what are the implications for countries that have social rights in their constitutions, or that have a special entity working on the specific characteristics of social rights as fundamental rights? Also, do you believe if there's a conceptual issue and understanding problem of fundamental rights and policies and guidelines? And the third question for you, David, is the proportionality test may not be the most adequate tools because we have problems from the distinction between principles and rules. So what do you think is the best way to approach the problems of conflict between fundamental rights? If there are more classic fundamental rights such as freedoms, and how we can perceive this in context where social rights are also fundamental rights. And now for David Bilchitz, we have the following questions. In relation to what you said at the beginning of the presentation, that the proportionality test might not be the most adequate way of thinking of positive obligations, what would be then the most adequate way if we don't use the test? And also, when we think about positive obligations, we think about social rights. So does your proposition at the end of the day, in order to solve conflict where social rights are involved, should we think of a different tool before using it? Any tool. And in that case, if you think of social rights directly linked to rights of freedom, another type of classical rights. So in that case, do you use several tools or only one instrument? What would be the formula here? There's a lot of interest in the proposition you shared on the huge necessity, because one of the huge necessities is understanding all of these visions. So some questions have to do with knowing how your proposition is related to the understanding, the need of the degree of necessity. And if it's not a problem for the judges to have 4 divisions or 4 stages in the test of necessity. If they have limited resources, for example, time and even in training, in legal training, sometimes they are limited in that aspect as well. And professional training, doing these specific analyses and complicated analyses that require more time. And one last question, I don't know if you have time to answer this third question, but someone from the audience remembers that in your conference a few years ago, you talked about capabilities and transitional justice, the process of transitional justice in South Africa. The example of South Africa has come up a lot of times during these conversations. So the audience is asking if you could tell us a bit more about how the transitional justice could work in this context with the tool of proportionality, especially because in these transitional contexts, what it's at stake is that there's no closed norm or strict norm or binding norm. Or so we do have a lot of questions, and if we have time, I will bombard you with more questions. So I don't know who'd like to start first, David or David Martinez.
I'm happy either way. Should I go ahead? Okay. Gracias. Okay, thank you. Should I proceed? Thank you for the questions. They're very, very interesting and issues, and some of them are related to the presentation I gave, and some of them are not so related. So I'll link the ones mainly that are related, and then we can discuss a little bit about the ones that are not so related as well. I think there was the first general question was about principles more generally, and we've heard a detailed and very complex analysis by David Martinez, and very impressive about principles. But I think a worry for me about that is it sounds so complicated that it almost is impossible to engage with. It sounds like discussions in high legal theory, which it is, and there's nothing wrong with high legal theory. But at the Supreme Court, you are concerned, and in the process of judging, you're concerned with actually the application of norms. And so you want to know how this kind of applies in some way. And so that's a question I have for David as well, in some senses of the practical application of the theoretical distinctions that he has made. I would say you shouldn't get confused by legal philosophers. The thinking by legal philosophers is meant to clarify, not to confuse, and to make the process of judging more difficult. Okay, and so the categories are meant to be helpful and not unhelpful. And when we think about something like a principle, like Dworkin or Lexi uses it, it is very much related to how we use that notion in ordinary life. Now, David has told us that there are many ways in which we use principles, which is true. But I would say one should think about, when engaging in the process of judging, those that are most useful and most helpful and that don't cause issues. And one of them that I try to suggest to you is that this conception by Alexi of optimization requirements, right? Fulfilling the principle to the greatest possible degree, the norm to the basic greatest possible degree, is itself highly problematic, because it leads to consequences that I've suggested to you, that we have to find measures that are equally effective. Alexi's conception is very clever, because the necessity test and the suitability test actually flow logically from his approach. Okay, he shows there's a logical derivation. But in terms of practicality, it is really problematic, because how can we equally effectively achieve the objective and have the least impact on the norm? And trying to do the least, as we saw, leads to the problems that the test becomes effectively unworkable, and it's either too strict or it's too weak. So I suggest that therefore we should we leave behind the notion of principles as optimization requirements, right? So we can have a big debate about that. And we should rather think about principles as strong reasons in favor or against a particular proposition. Okay, it shouldn't be complicated in a way, right? It's actually kind of things that we think about. If I hold a principle, I hold a strong view in favor of a particular proposition, and that principle may conflict with other principles. And the proportionality inquiry is a method of trying to address the conflict that can arise between reasons of weight, because fundamental rights are strong reasons, right? That's why we have fundamental rights, because they are themselves reasons that have strong normative weight in and of their own right. Okay, and so therefore they are strong reasons in favor of privacy, for example, And in order to overturn that, we need something equally strong, perhaps protecting life from terrorist attacks. And then we have to work out how these two relate to each other, okay? And so that's my view about how we should engage with it, but it's something that obviously we could discuss a lot more, but that's my view about how we should move to think about principles. About social rights and civil and political rights, I don't know. I think David was describing the situation in Spain, but Spain has a very particular constitutional system. And in many cases, like my country, like South Africa, and as I understand Mexico as well, social rights are now justiciable rights. They are not just social objectives. They are actually rights to be given effect to in the Constitution itself. And as norms on an equal weight to civil and political rights. I think that is absolutely correct. I think there is a mistaken focus only on civil and political rights, not that they shouldn't be focused on, but so we care about rights protect our fundamental interests as individuals. And as such, those interests are not just about freedom. They are also about basic access to goods like housing, healthcare, food. And we see the madness, sorry to say this, of the conception of pure civil political rights only mattering in your neighbor in the United States, right? Of where people can literally die for lack of access to healthcare, right? In a very, very wealthy country. And you then tell me that only freedom matters? This doesn't make any sense, okay? So most theorists today have rejected this strong division between civil and political rights and social and economic rights. My early book, which is also in Spanish now, I think it's Pobreza y Derechos Fundamentales, Poverty and Fundamental Rights. And that book essentially defends a conception of rights from the start, which includes both civil and political and socioeconomic rights. And the division is really a Cold War division, which should be rejected outright by human rights advocates or fundamental rights advocates. Okay, and these constitutions that are older they were constitutions that were, that were influenced by ideas that were early on in the time. And India, for example, also includes, at the time, they didn't include social rights as fully justiciable rights. And now the Supreme Court in India now has read social rights into the civil and political rights. I'm not sure what the situation is in Spain, but this was before the big turn in the late 1980s and early 1990s, where the constitutions now include justiciable social rights. And I know that I'm going to also be speaking at some stage to Mexicans about social rights further. We also had a conference a few years ago as well. So I'm going to leave that there. There was a question about, I want to leave some time for David as well. Sorry, I just need to plug in my computer is losing power. There was a question about positive obligations and proportionality. It's a large topic in and of itself. Let me say that let me just give you a brief understanding of the reason proportionality doesn't work well with positive obligations is because it deals with an omission. Ultimately, it's a failure to act. And there are grave difficulties in saying, what is the purpose of failing to act, right? What is the purpose? Is it a legitimate purpose of failing to act? Okay, and that then leads to real problems applying the test when it comes to suitability, necessity, and balancing. And so the question was, what is the alternative? Well, again, that requires its own conference. You can read chapter 8 of my new book where I engage with this and I propose a new test in relation to private actors like corporations. But there is also a lot of discussion in the Colombian Constitutional Court has done excellent work in looking at how to give effect to social rights in reality. And my court, the Constitutional Court of South Africa, I don't think it's a great example, but it has used ideas of reasonableness and tried to develop those ideas a little bit in giving effect to social rights. So there is a question of the framework for dealing with not social rights, the positive obligations flowing from social rights. So let me be clear. The negative obligations, proportionality will apply. The problem is what we often call in human rights law, the duty to fulfill, the duty to provide a house or the duty to provide food. In those cases, we need a different framework. Okay. Then let me just have a look. One quick question was about, haven't I made this just a bit too complex with another? Now we've got 4 stages of proportionality, and now we have 4 tests under necessity as well, right? And yes, I understand that that's a problem, but I think the point that I try to do is to try and make it clear what is needed when you're doing a necessity test. So instead of, as I said, making things complicated, I hope that it sheds light on what judges are actually doing. So judges can actually think through those processes. I think it would be a good idea, and it may even help judges to use those 4 stages. But it may be in many cases that, for example, the question of possibility, you've got 2 alternatives clearly in front of the court. So it doesn't need to go into that in detail. Okay, and so it will ultimately look at the effectiveness of the alternatives, the impact on the right, and weigh them up against each other. The stages are put there, the 4 elements are components that are, in my view, conceptually part of the necessity test. But I'm not sure they need to each be done one after the other. I think they need to be considered, and judges help in the adjudication process to think about them in many ways. I was asked last year, and this is really not close to our topic, so I think maybe I'm going to give David, I don't want to duck the question about transitional justice in South Africa and proportionality. I think it is important in relation to, again, harms to rights, and we have to think about whether the objectives of transitional justice can allow for certain harms to rights. And we had a very exciting case in South Africa called the Azapo case, a difficult case for the Constitutional Court, which in our transition, the perpetrators of terrible crimes were allowed to get amnesty from criminal and civil prosecution. And the families of victims came to the Constitutional Court and they said, we are being deprived of our right of access to courts. Okay, and so the Constitutional Court had to weigh up the right of access to courts versus the objectives of the transition and the Truth and Reconciliation Commission. And in that process, it uses, to some extent, although it could have done it better, it uses a proportionality test. So you can look up that judgment. It's called the Azapo judgment. And I think it is relevant in applying it in those kinds of very difficult situations which face courts and other actors in situations of transitional justice. So with that, I hand back to and over to David Martinez. David, over to you.
David. El micrófono.
Your microphone is muted. Yes, sorry. Thank you so much for all the questions. I will try to answer them. But yes, I think we need another session to discuss all of these matters because it's so rich. So to answer the first question, that has to do with my vision of distinction and what impact it has. And I believe that at this point, I have read enough to know other visions, and I can say that there are so many different elements that are qualified as principles, and it's reasonable to call them principles. However, any attempt to change this, I think, will fail. There's also an important distinction between norms and hypothetical norms that was proposed or submitted by the School of Lisboa. So we have a lot of interesting examples regarding this. And it's that I believe that distinction for practical effects is not so relevant. We're talking about what is the best way to provide an answer to conflict situation with these elements that are involved. These are very important elements, such as fundamental rights. So how can we give the best answer, the most reasonable and justifiable answer to these conflicts? And in this sense, I don't think that it matters if we qualify principles as principles and rules. What's important is to have the correct procedure to provide the best answer we can. And in this sense, proportionality is a very promising tool and one that we should take into account. So I believe that the proportionality test is an important tool. There are some points, for example, the alternative measures and how to, I think that is more satisfactory than Alexi's theory. That has to do with the proportionality model. So I think this is a normative issue rather than separating concepts between principles and rules. Regarding social rights, how they are categorized and how they play into proportionality, I believe it depends on how the legal system is set. In the case of Spain, Spain is no exception in the European context. A lot of Western European countries have stated in their constitutions social rights. And what we perceive from them is that it has to do a lot more with public policies rather than legal aspects. So it has to do with public policies. Satisfying at a minimum degree public needs is a task for the government. So it's better to have a good household policy than rather grant a home to a person that is living on the street and they have to go to the office to get that benefit. So in some cases in Spain, we have the well-being models for health services. Even though in Spain, it's not seen as a fundamental right, as you probably know, Spain does have a universal assistance health service that is very generous compared to other systems around the world, and it has it's a universal consensus. And there's no question about this. So it depends on the weight you give to the issue, but no one questions universal health service. So I believe it has to do with public policies rather than individual fundamental rights. Linked to this, if the constitutional consideration, as I understand in Latin America, see social rights as authentic subjective rights, as well as traditional rights, then the way we act and we reason legally, it has to be equal or similar to those of civil and political rights, if they are at the same level. However, social and political rights from an economic point of view are rights that are cheap. I'm sorry to say it like that, but freedom of an infringement to freedom of expression to the public powers, it's not as costly or expensive to solve compared to the infringement of other rights. For example, recognizing same-sex marriage. So the state can easily change that norm, but it doesn't happen with social rights. We always think about the economic cost, and so the consequences are clear. And when it comes to the interpretation of the scope of those rights, if we consider this as an authentic subjective right, then I can go to the court and claim it. So if we suppose in a household that each individual has a specific amount of square meters, then the household should measure those square meters. A dignified household has its definition, and how it should be, it's defined in the law. So it's an important aspect to take into account. And this will entail a huge problem for the public powers to respect social rights. So there might be some issues that come up to meet the needs in those cases. So compared to civil rights that are more expensive, than social rights are less expensive. And to answer the other question regarding the alternatives to the criteria, I think it's the proportionality model has a lot of virtues. However, it has no conceptual connection to the rights as Alexi and other authors think. I think it's rather to think what tool we can use to solve better conflict resolution. And I do think there are alternatives that are interesting that we can consider. Thank you so much, David and David. I don't know if you'd like to share just a general conclusion or some closing words. We don't have much time, but we do have a couple of minutes to spare.
Thank you very much. I think it's been excellent to be here. I think David and I have differences on social rights and the justiciability of social rights. I certainly think that civil and political rights are also expensive, actually, in terms of if you think about what's required for a criminal justice system, legal representation, if you think about what's required to have a public broadcaster to ensure freedom of speech is equally accessible. So it seems to me that there are resource implications for both sets of rights. And we need to think less, and there are also possibilities, for example, to prohibit eviction in a certain way, which with actually less costly implications of social rights. So, but that wasn't the focus of our discussion. I think the focus was on the proportionality test, and I think you've heard, I think, my perspective about taking account and thinking very seriously about the various components of proportionality. I went into necessity today in detail, but of course, all the components are really important, and they are what provide the benefits of the proportionality inquiry, which is really about structuring the way we reason when we think about rights and where we have clashes of different principles and different normative considerations, and to be able to ensure that when we allow rights to be violated, we have a strong justification for that to take place, because it's a very serious thing when rights are violated. So I hope that has been useful, and thank you very much for having me.
Yes, simplemente.
Yes, once again, I would also like to say thank you for inviting me to this session. It was a very interesting session. I hope that everything we shared was useful for all of you. And greetings to Mexico and to everyone else, to everyone who is seeing us. And hopefully we'll see you soon. Yes, so thank you, both of you. I hope we could have more time to continue with this debate, but unfortunately, we need to close this session. And I think that this discussion we had shows how important it is to discuss the proportionality inquiry. And it's not only a methodology or an abstract tool, but it has concrete and important implications on how rights are being set. So it's a two-way street issue, how the test is applied, but also what it does regarding rights. And all the other topics that were very interesting as well during the presentation. So thank you so much. And we should keep going deeper on this. So once again, thank you to both Davids for their excellent presentation, and to all the audience, all the participants that logged on from our social networks and from the Supreme Court here in Mexico. You are all invited tomorrow for Virgilio da Silva conference, who will also talk about the necessity test. So see you tomorrow, 9 a.m. Mexico City time. Have a great evening or day, everyone.
Bye.